Right now, as you are watching this, the highest court in the United States is rewriting the rules of American life. Not next year, not after the next election, right now. 9 justices, 6 of them appointed by Republican presidents, 3 of them appointed by Democrats, and this court, this 6-3 supermajority, just handed down a series of decisions that will reach into your home, your family, your elections, and your rights in ways most people don't even realize yet. We are going to break down exactly what happened, what it means for you, and what is still coming, because the most explosive ruling hasn't dropped yet. That one lands in days. Stay with me, because by the end of this video, you are going to understand this moment better than most Americans and most of the media ever will. The court nobody explained to you. Before we get into the rulings, and we are going to go deep on every single one, you need to understand what this court actually is right now, because there is nothing like it in American history. The United States Supreme Court has 9 justices. They serve for life. They are nominated by the president and confirmed by the Senate. And right now, 6 of those 9 were appointed by Republican presidents. Donald Trump appointed 3 of them. Alone, that 6-3 split sounds simple, but here is what it means in practice. In most cases, if those 6 justices agree on something, it becomes the law of the land. The 3 on the other side can write dissents. They can call it wrong, dangerous, historic, but none of that matters. The majority wins, and the ruling stands. Now, the court decides hundreds of cases every year, and many of them are completely non-controversial. Both sides agree. Nobody is fighting about it. But the cases that define America, the ones about your rights, your elections, your body, your family, your citizenship, those tend to split right along that 6-3 line. And this term, the 2025 to 2026 term that split, has happened more than any term in recent memory. As of the last week of June 2026, the court has already handed down more 6-3 ideological decisions than it did in the entire previous term. And the most explosive cases, they are still coming. The justices are racing to release everything before their summer recess, meaning the biggest rulings are dropping right now this week. So let's go through them one by one. Plain language, no spin, just the facts and what they mean for you. The Voting Rights Act is gone. We need to start here, because this one has the most immediate real-world impact, and barely anyone is talking about it outside of legal circles. On April 29, 2026, the Supreme Court handed down its decision in a case called Louisiana versus Callis. The vote 6-3 along ideological lines. And the ruling? It effectively gutted one of the most important laws in American history, the Voting Rights Act of 1965. Now, let me tell you what the Voting Rights Act was, because you need to understand what just changed. After the Civil War, the 15th Amendment gave Black Americans the right to vote, but for nearly 100 years, states found ways around it. Literacy tests, poll taxes, threats, violence. Black Americans were on the voter rolls in name, but shut out in practice. Then came 1965. The Civil Rights Movement, the marches, the beatings on the Edmund Pettus Bridge in Selma, Alabama. President Lyndon Johnson signed the Voting Rights Act into law, and it had teeth. It said that if your election maps, your voting laws, or your districts were designed to diminish the voting power of minority communities, you were violating federal law, and you could be sued for it. For 60 years, that law was the backbone of fair elections in America. Here is the case that just changed that. Louisiana is a state where roughly 1/3 of the population is Black. For decades, the state only had one majority, Black congressional district, meaning Black voters only had real influence over 1 out of 6 seats. Civil rights organizations sued and won. A federal court ordered Louisiana to redraw its maps to create a second majority Black district where Black voters could actually elect someone who represented them. Louisiana did it, and for the first time in the state's history, 2 Black Louisianans were elected to Congress. Then a group of self-described non-Black voters filed a lawsuit claiming that the new map was itself an illegal racial gerrymander. The case went all the way to the Supreme Court, and the 6-3 majority sided with those challengers. The court struck down the map. It ruled that Louisiana had gone too far in considering race when drawing those districts. But here is the devastating part, and Justice Elena Kagan read her dissent from the bench, which she only does when she believes the court has made a historic error. The ruling doesn't just apply to Louisiana, it fundamentally weakens Section 2 of the Voting Rights Act, the provision that protected minority communities from being drawn out of political power. Legal experts say the decision opens the door for states across the South to redraw their maps, potentially eliminating majority Black and majority Latino districts entirely. States like Mississippi, Alabama, South Carolina, Tennessee, Florida. Within days of the ruling, several of those states began moving to redraw their congressional maps. Think about what that means. This is not abstract constitutional law. This is about who represents your community in Congress. This is about whether your vote in your district actually counts for something, or whether politicians can carve up neighborhoods and zip codes to make sure certain communities never have real political representation again. One senator celebrated the ruling saying, and I quote, "It confirms that the government cannot treat you differently based on your race." The NAACP Legal Defense Fund said they were horrified that the court had trampled not only on the rights of Congress to protect voters, but on its own previous rulings, setting aside decades of precedent to reach this outcome. This ruling is already reshaping the political map of America. With the 2026 midterm elections approaching, experts say this decision could help Republicans lock in congressional seats in states where demographics have been shifting. And what happens to those two Black representatives from Louisiana who were just elected? Their districts are now under threat. The week everything broke loose, that voting rights ruling was the biggest 6-3 decision of the term so far, but it is not the only one. On Tuesday, June 23, 2026, and this week the court released 5 decisions before noon. 4 of those 5 were 6-3 splits along ideological lines. 4 out of 5 in a single morning. Let's go through what happened. Decision 1, the Rastafarian prisoner. A man named Damon Landor is a practicing Rastafarian. Part of his faith involves wearing his hair in dreadlocks. He was incarcerated in a Louisiana prison, and prison guards forcibly shaved his dreadlocks. Removing a Rastafarian's hair is not just a haircut. For many practitioners, it is a profound violation of their religious identity. Federal law is supposed to protect the religious rights of people in prison. 2 federal laws, the Religious Freedom Restoration Act and the Religious Land Use and Institutionalized Persons Act, exist specifically for this. Landor sued the guards for violating his rights, and the 6-3 majority said he cannot sue for money damages. Even in this case, where nearly everyone, including the state of Louisiana itself, acknowledged Landor was treated unfairly, the court said he had no legal remedy against the individual officers. The dissenting justices said this ruling closes the courthouse doors to anyone whose religious rights are violated in prison. No damages, no accountability, and no realistic way for Congress to fix it without passing entirely new legislation. Decision 2, Exxon and the Cold War. In another 6-3 ruling the same day, the court allowed Exxon to pursue a lawsuit over property that was confiscated by the Cuban government back in 1960, over 60 years ago. The court ruled in favor of the oil giant's legal standing to pursue that decades-old claim. Critics pointed out the contrast. An imprisoned man whose religious rights were actively violated this decade cannot sue for damages. A multinational oil corporation pursuing a 60-year-old Cold War grievance. The court gave it a green light. Decision 3, Cisco and China. Also on Tuesday, in a case called Cisco Systems versus DOE, the court blocked a lawsuit against the American tech company from people who say China's government persecuted them for their religious beliefs, and that Cisco enabled that persecution. By providing the surveillance technology the Chinese government used to identify and track them, Justice Amy Coney Barrett wrote the majority opinion. She acknowledged the cases involve, and I quote, heinous and inhumane acts. But she said American courts cannot create new remedies for international human rights. Violations under the laws being cited. Justice Sonia Sotomayor, in a scorching dissent, said the ruling closes the courthouse doors to virtually every future victim seeking justice for international human rights abuses under American law. She called it, in her words, another low point in this court's esteem for its precedents. So in one single Tuesday morning, the 6-3 majority ruled that a religious prisoner cannot sue for damages, a surveillance tech company cannot be held liable for enabling state persecution, and a massive oil corporation can pursue a 60-year-old claim. That pattern, who wins and who loses, is what critics are pointing to when they say this court is not just interpreting law, it is reshaping it. The bomb that hasn't dropped yet. Now we get to the one that may be the most consequential ruling in a generation. It has not been decided yet, but it is coming within days, possibly before this week is over. The case is called Trump versus Barbara, and it is about a question so fundamental that the answer could change who counts as an American. Birthright citizenship. Here is what birthright citizenship means. If you are born on American soil, you are an American citizen, period. It does not matter where your parents are from. It does not matter what their immigration status is. If your first breath is drawn in the United States of America, you are a citizen of the United States of America. That principle has been embedded in the 14th Amendment to the Constitution since 1868, written in the aftermath of the Civil War, to guarantee that formerly enslaved people and their children could never again be stripped of their American identity. And in 1898, the Supreme Court affirmed it explicitly in a landmark case. It ruled that a man named Wong Kim Ark, born in San Francisco to Chinese immigrant parents, was a United States citizen. That precedent has stood for 128 years. On his first day back in office in January 2025, President Trump signed an executive order attempting to end birthright citizenship. The order said that children born in the United States to undocumented parents or to parents here on temporary visas like student, work, or tourist visas would no longer automatically receive citizenship. Federal courts immediately blocked it. Multiple judges, including conservative ones, said it was unconstitutional. The legal challenges worked their way up through the system until they reached the Supreme Court. Arguments were heard on April 1st, 2026, and what happened in that courtroom was extraordinary. Even the conservative justices, the 6-3 majority, showed serious skepticism toward the Trump administration's argument. Chief Justice John Roberts pushed back hard. He challenged the government's attempt to use narrow historical exceptions, like diplomatic immunity for ambassadors' children, and expand them into a broad rule that would exclude millions of children from citizenship. Roberts said, and these words were widely reported, "It's the same Constitution." Justice Neil Gorsuch, one of Trump's own appointees, scrutinized the historical basis of the administration's argument. Justice Sonia Sotomayor asked the Solicitor General a simple, human question. Are you suggesting that when a baby is born, people have to present documents? Is this happening in the delivery room? The administration's top attorney said yes. Parents could contest the government's determination of their child's citizenship status, but only after the fact. Legal scholars across the political spectrum say the questioning strongly suggests the court will rule against the administration and uphold birthright citizenship as it has always been understood. But here is why this still matters deeply, even if Trump loses the case. We do not yet know the ruling. It is expected on or around June 30th, 2026, that is days from now. And even if the court upholds birthright citizenship in this case, the fact that this question was seriously litigated before the highest court in the land and that it reached this point means this fight is not over. Because here's what is at stake. There are an estimated 250,000 to 300,000 children born in the United States every single year to parents who are undocumented or here on temporary visas. If this executive order were ever upheld, every one of those children, starting from the date the order took effect, would not be American citizens. They would be stateless, born here, raised here, speaking English, going to American schools, but not legally American. A poll conducted in April 2026 found that 64% of Americans oppose ending birthright citizenship, only 32% support it. But polls do not decide constitutional law. 9 justices do. Watch for this ruling. It may drop before you wake up tomorrow. And whichever way it goes, it will define what it means to be American in 2026 and beyond. And the power of the presidency. There is one more case in this final burst of decisions that could reshape American democracy in ways people are still not fully grasping. The case is Trump versus Slaughter. Here's the background. For more than 90 years, since a Supreme Court case in 935 called Humphrey's Executor, it has been settled law that certain federal agencies like the Federal Trade Commission, the Consumer Product Safety Commission, the Federal Reserve Board, are independent. They exist inside the executive branch, but the people who run them cannot simply be fired by the president because the president disagrees with their policies. The whole point of that independence is to insulate agencies that regulate American business and protect American consumers from pure political pressure. The FTC, for example, is supposed to be able to investigate corporate monopolies, even if the president's political donors happen to run those corporations. In March, President Trump fired Rebecca Slaughter, a Democratic member of the FTC, and said keeping her was inconsistent with his administration's priorities. She sued. The case is now before the Supreme Court. If the 6-3 majority rules that the president can fire members of independent agencies for political reasons, the entire concept of independent regulatory agencies could collapse. Every commissioner, every board member, every inspector general, all of them suddenly serve at the pleasure of whoever sits in the White House. That would represent the largest expansion of presidential power over the regulatory state since those agencies were created, and it would come at a moment when the administration is already pushing the limits of executive authority on multiple fronts. The ruling has not been released yet, but it is coming before the summer recess, which means within days. Think about what that means for everyday Americans. The FTC is the agency that stopped your cable company from burying unfair fees in fine print. The Consumer Product Safety Commission is the agency that recalled the baby product that was killing infants. These agencies exist because Congress decided decades ago that some things are too important to let politics interfere with. One ruling from 9 justices, 6 of them appointed by Republicans, could change that permanently. What this all means for you. So let's step back, because I want you to understand the full picture of what this week represents. In the span of a few days, the Supreme Court has handed down or is about to hand down rulings that affect your vote. The Voting Rights Act has been weakened in a way that could determine who represents you in Congress for the next decade. States are already moving to redraw maps that could eliminate minority representation. Your district could change before the next election. Your religious rights. If you are ever in a position where a government institution violates your ability to practice your faith, this week's ruling makes it harder to hold individual officials accountable. Who counts as American? If you or someone you love was born in this country to immigrant parents, or if you are pregnant right now and your status is not permanent, the ruling in Trump versus Barbara could determine whether your child is a citizen of the country where they were born. Who controls the government? If the court sides with the administration in the FTC case, the independent agencies that protect consumers, workers, and investors from corporate abuse could be brought under direct political control. These are not abstract legal debates. These are the conditions of real life in America in 2026. And here is the thing that nobody is saying loudly enough. The Supreme Court does not answer to voters. Justices serve for life. They are not on the ballot in November. They cannot be recalled. And with a 6-3 supermajority, 3 of those 6 justices were appointed by the same president who is now winning some of these cases before the very court he reshaped. Justice Sotomayor has already warned from the bench that this pattern shakes the public's confidence in the stable and predictable development of the law. Whether you think these rulings are correct or catastrophic, one thing is simply true. The institution that has final say over the laws you live by is more ideologically concentrated and more willing to overturn decades of settled law than at any point in modern American history. Here is where we are right now. The Voting Rights Act has been fundamentally weakened. Multiple 6-3 rulings this week have narrowed individual rights while expanding corporate and government power. The Birthright citizenship decision is days away and could redefine who gets to be called American. And the FTC case could hand the executive branch more power over the regulatory state than at any point in 90 years. All of this is happening in a single week at the end of June 2026. This is not politics, this is history, and it is happening right now. If this video helped you understand something you did not understand before, share it, because millions of Americans are about to be affected by these decisions and have no idea they are coming. Like this video, subscribe so you see the follow-up when the Birthright citizenship ruling drops, because that breakdown is going to be even bigger than this one. And leave a comment below. Tell me which of these rulings concerns you the most. I will see you in the next one.